Ladies and gentlemen, first of all, I would like to thank for having been invited to this conference and to talk about the development of judicial independence in Austria, a marathon instead of a sprint race, as chosen as title. Judicial independence in Austria was achieved, if ever, step by step. The development did not proceed in the sense of a straightforward, continuous progress, but was marked by setbacks again and again. This justifies the comparison with a marathon. Our marathon can be broken down into several sections. The first is the period before 1848. In this period, the Austrian constitutional situation was characterized by monarchical absolutism. As the sole bearer of state power, the monarch was also the supreme judge and could intervene in any proceedings by issuing power decrees. Judges free from monarchical influence would have contradicted this absolutist concept. Therefore, judges were civil servants like others, which was, for example, reflected in their uniforms from 1814 onwards. The situation was different in the case of the manorial patrimonial courts, which existed below the state courts as the quantitatively most important institutions for the administration of justice. In Lower Austria, for example, Lower Austria alone, there were more than 800 such manorial courts. The owners of the manors were free to decide how to discharge their obligation to conduct judicial business. Some carried out judicial activities themselves, some used freelance attorneys who could perform this task for several manors. In most cases, however, the lords of the manor hired corporate counsels to whom they assigned other tasks as well. In none of these cases there was any judicial independence. The patrimonial judiciary therefore became a major target of revolutionary criticism. The next period, from 1848 to 1851, although the Constitution of 1848 declared that all administration of justice emanated from the emperor and was exercised in his name, the abolition of patrimonial jurisdiction was not officially declared until September 7, 1848. The Constitution immediately contained programmatic provisions. Judges were to be dismissed, demoted, transferred, or pensioned only on the basis of a judicial decision. However, the intended strengthening of the judicial position was not explicitly characterized as independence. Even before these regulations could be implemented by simple legal regulations, the constituent Reichstag, the new parliament, had already devoted itself to the project of a new constitution and, in doing so, also to judicial independence in a detailed manner. Judges were appointed for life. They can only be removed from office or impaired in rank or salary or suspended by verdict of the Supreme Court, and they can be transferred to another post only with their own consent, was the quotation. Moreover, a remarkably far-sighted provision against indirect dependencies of the judges was stated. No judge, quotation again, no judge was allowed to accept a salaried position from the government in addition to his office. This draft constitution never became law, but it influenced the constitution of 1849, which followed the example of the Reichstag draft with a separate section entitled Von der richterlichen Gewalt on judicial power, in which its independent exercise was established and the abolition of patrimonial jurisdiction was affirmed. Permanently appointed judges were to be suspended, dismissed, transferred, or retired only on the basis of a judge's decision again. However, there was no prohibition on accepting other salaried positions in addition to the office of a judge, and thus becoming dependent on the government. But not all judges were to enjoy constitutional protection even in the longer term. For the first time, a differentiation within the judiciary emerged that would recur in future developments. A distinction was made between two groups: those to whom only independent judicial functions are assigned, presidents, senate presidents, councillors and district judges, Those were considered judges in the sense of the Constitution, while the others, as auxiliary officials of the judge, assessors, adjuncts, assistant assessors, were different names, were not given the character of a definitely appointed judge. The first group of independent judges could only be punished, suspended, or retired by the competent disciplinary court, except changes in the organization of the courts. The assessors, adjuncts, and so on could be transferred, and they could also be dismissed administratively by the Minister of Justice. Thus, their position under civil service law was not different from that of civil servants and servants of the other branches of administration. However, these non-independent judicial officials, who were always threatened with dismissal or transfer, were persons who functionally acted as judges, but for whom the protective mechanisms to guarantee independence did not operate. Contrary to the ideas of constitutionalism, they were not permanent and transferable judges. This was not a marginal group. For example, again in Lower Austria, excluding Vienna, there were 74 district courts in which a total of 183 academically educated persons were active. Most of them can be compared with today's judges. For each district court, there was only one district judge who, as an independent judge, benefited from the protective mechanisms outlined before. This results in a total of about 40% of the judges, while independence was not guaranteed for the remaining 60%. The next period, from 1852 to 1867. From what I said before, the turn of the year 1852, which ended the first constitutional period, was not a serious caesura. In fact, the separation of the administration of justice from the administrative authorities was generally limited to the collegiate courts or the second and third instances. Otherwise, in the case of the individual courts as first instances, the connection with the administration in the district office was carried out. This created the mixed district offices, typical for the period of the so-called neo-absolutism. They were characterized precisely by the connection between judiciary and administration, even if this should be hidden from the public as much as possible. The rejection of a special position for the judiciary within the administrative apparatus was also evident with regard to the people involved. Judges could be also dismissed or retired, just like other civil servants. Officials or servants, including judges, who, quotation, disgraced themselves by indecent or immoral conduct, end of quotation, or who exhibited blameworthy political behavior, were threatened with various disciplinary sanctions. There was no protections against transfers. Retirements due to incapacity or unfitness for service, reasons of age were not specifically mentioned, were subject to the same provisions as for civil servants in general. They were ordered administratively. Thus, judicial independence did not exist during these years. This is made particularly clear by cases of resurgent cabinet justice. The next period, starting in 1867, has already been mentioned by Dalibor in some aspects. Returning to constitutionalism in 1867, a separate state basic law on the judiciary stipulated the definitive appointment of judges for life, their autonomy and independence in the exercise of their judicial office and extensive protection against removal from office and involuntary transfer to another position or transfer to retirement. The parliamentary materials on this law show the widespread acceptance of the principle of judicial independence. Nevertheless, there was a long discussion on the topic of retirements due to age, which cannot be retold here. I will give more information in the written version of my paper. In connection with the retirement issue, another aspect of independence was touched upon in the House of Lords, which is of timeless importance. It was also already slightly mentioned by Dalibor. One member of the House of Lords declared it to be significant for judicial independence that judges are assured not only a poor living standard, but a decent, reputable one. In the following time, as in the 1850 legislation, the Judges' Disciplinary Act of 1868 again divided the judicial officials into independent judicial officials and judicial auxiliary officials. Only members of the first group were to be regarded as judges within the meaning of the state basic law on the judiciary. They were independent in the exercise of their judicial office and, except for changes in the organization of the courts, again, could be transferred only on the basis of a disciplinary court order. The auxiliary officials could be transferred or retired in the interest of service, even without their consent and by administrative means. All this created a glaring contradiction between the guiding principle and the concrete regulations of the judiciary. Especially in the very many so-called small claims proceedings, up to an amount in dispute of 50 guilders, the district judge usually had to decide. However, where he alone would not be able to cope with the business burden, as was told, other judicial officials could be appointed to this by order of the President of the Court of First Instance. Civil servants appointed in this way to exercise the office of a judge in a minor procedure did not thereby alone acquire the status of independent judges within the meaning of the Judges' Disciplinary Act. Therefore, they could be removed from the exercise of this office at any time by order of the President of the Court of First Instance for reasons of service. In the following decades, this problem intensified. Although judicial power remained centered in the person of the district judge, in practice the judicial assistants took over more and more tasks. This was not accompanied by an expansion of the constitutional concept of judges. Independence and permanency, in the sense of the state basic law on judiciary, continued to be granted only to independent judicial officials. The situation of those persons who functionally acted as judges therefore did not satisfy constitutional requirements even in the last decade of the 19th century. The next period starts 1898 with the introduction of oral proceedings by Franz Klein's civil justice reform from 1898 coming into force. The use of the judicial auxiliary officials for judicial activities became impossible. In this sense, the 1896 Court Organization Act expanded the group of independent judicial officials to include also the single judges employed at the district courts. The segregation of judges from the general administrative civil service became also visible through the end of uniforms and the introduction of the gown. The professional self-consciousness of the judges was expressed not least in the founding of the Judges Association in 1907, also already mentioned by Dalibor Cepolo. Next period, starting in 1918 until 1920, the Provisional National Assembly of the newly founded state of German Austria enacted a basic law on judicial power in November 1918. It adopted the norms of the state basic law from 1867, but also contained remarkable innovations. Above all, judicial independence was strengthened by introducing a right of self-determination in staff recruitment and career affairs. Instead of a free right of the head of state, appointments were to be made on the basis of proposals of personnel senates. Subsequently, no candidate not included in the proposal for appointment was to be appointed. Another new aspect was the legally standardized retirement upon reaching the age of 65. Before reaching the new age limit, judges could only be removed from office, transferred or retired in cases prescribed by law on the basis of a judicial decision. Again, except changes in the constitution of the courts. This happened immediately with law on changes in the constitution of the courts, and according to this law, judges could be transferred or retired until December 1920 because there were changes of the present court system. Finally, stronger regulations on the distribution of business also strengthened judicial independence in this period. The almost last period, starting in 1920, with the new federal constitution of 1920, this constitution declared that judges were independent in the exercise of their judicial office and guaranteed non-transferability and permanency. This again excluded those cases necessitated by changes in the constitution of the courts. Thus it followed in general the basic law on judicial power of 1918. But again there were changes, especially the right of self-determination in staff recruitment and career affairs of personnel, which had been a highlight in the development of judicial independence, was dropped again, primarily for political reasons, according to the famous Austrian lawyer Hans Kelsen. The determination of an age limit for retirement was now left to simple legislation. The Federal Constitution of 1920 created the basis for even today's judicial independence and remains significant for many decades. However, it is necessary to keep in mind important interruptions by authoritarian regimes between 1933 and 1945, which cannot be reported here because I have to come to an end. Therefore, I will reserve detailed explanation for the written version of my paper. Finally, I would like to have a short glimpse on the period after 1945. The situation in May 1945 was restored as it had existed before, the turn to authoritarian regimes. Criticisms and wishes from the First Republic were also revived. The trend towards the emancipation of the judiciary from the civil service of the general state administration reached its provisional conclusion in 1962 with the Special Judges Service Act. In public discourse today, there is probably more frequent talk about independence of judiciary than of independence of judges. In this context, judiciary encompasses more than the legal position of appointed judges. In 2008, the public prosecutors as well have become organs of the ordinary jurisdiction. This was caused by a criminal procedure reform which transferred especially investigative judicial work to the prosecutors. This broader understanding was also confirmed by integrating the prosecutors into a new Judges and Public Prosecutors Service Law. The still unsolved question of a federal public prosecutor's office as an independent head of instructions for all prosecution of authorities has also been occupying Austrian politics for years and is understood as an aspect, still unsolved aspect, of independency of the judiciary in our media reports. Thus, recent developments also support the claim made at the beginning that the history of judicial independence is more of a marathon than a short distance race, and it is unclear whether we have already passed the 40th kilometer in this process. Thank you.